Probate, that's when you take the will that you made while you were alive and someone on your behalf files it after your death along with a petition. That's a request for the court to validate the will and to confer the permission and authority to act on behalf of a person, your executor. The executor takes the steps that are baked into the trust. The executor takes the steps baked into the will. Last will and testament has an executor. It might say, sell this property, disperse this bank account, take the proceeds of the sale and do something with it, take my shares of stock and do something else with it. Within a will, you can have a trust. It's a testamentary trust. So your will could provide for infant or minor children. So you could say, I'd like to leave a certain amount of money to my grandchildren to be held in trust for their benefit until they reach the age of 25, 21, 20, 36, whatever you like, whatever you'd like to do. So a trust, a revocable trust or an irrevocable trust, is a more robust stock. It can do more. It can accomplish more. It's more flexible. But in some instances, a will can be fine. A simple estate, a will is fine. An uncomplicated estate, fine. A multi-million-dollar estate, but with a simple distribution plan, maybe a will is okay. I don't know if you've taken care of other things and you have a comprehensive estate plan, but let's talk about it. And if you have millions, and even if it's simple, you might not want a will, but we can talk about why that might be. We can talk about your own circumstances. So that's what a will does. That's who it's for. What controls a trust or a will? The circumstances are, I was contacted by a person that his parent passed away, leaving a trust. The trust directed that certain estate property go to persons other than this prospective client. So let's give a scenario. 4 kids, 1 parent, some properties were going to the other 3 children. Asked me about that, what could be done, and whether there's cause for an action. Is there a certain type of litigation that can address that circumstance? He also advised that there was a will, cannot get or receive a copy of the will. He believes that one of his siblings has the will, or he understands that to be the case. And that sibling says, you don't need to see the will. The will isn't going to be used. That could be the case. It could be the circumstance that when the person passed away, none of their assets were in their personal name. If you have no assets in your name personally when you pass away, or even if you own it in a corporation, but if it's in your individual name. So an individual owns a corporation that owns a property, not a trust owns a corporation that owns a property. So if a person has an asset in their name, then you have to probate a will because it wouldn't have been in the trust. So if I have a property inside of the revocable living trust of Frank Bruno, well, then you never have to use my will when I pass away because you just have to administer the trust. Make sense? If I have an asset, I own a property in my own individual, and I also have a trust, you still have to go by my will because I owned that house, that property in my name at the time of my passing, and I can't sign a deed. So you need to get the permission and authority of the court for someone to be made executor, a fiduciary for my estate, to sign a deed, to make a contract, to get the house from my personal name into the names of my loved ones, or to sell it and then divide the money. So this person that called me may be in a terrible position where he was provided for in the will, then a subsequent trust left him. I have to look at all the documents, but it could very well be that the will, even though written, will never be used. I'll give you a different example. Let's say a person has $10 million in their name and they write a will. I leave everything to my son. Then they spend the $10 million during their life and they have 0 at their death. Well, it doesn't matter that the will says everything to my son because it no longer exists. The person in that example spent their $10 million. So the son that was going to receive $10 million will receive 0. And that will never be probated because there's no estate assets to probate. Same way that the trust would take over because there's no will probate. There is a will to probate, but there's no assets to distribute. If you have questions, reach out, frankbrunolaw.com.